Hi, welcome to GwinnettGunTrust.com. I'm Wally Nichols, attorney at law in Dunwoody, Georgia. I wanted to speak with you about recent events, not necessarily specifically gun trust, but here we speak all things gun related, and especially gun trust. We'll get into the nuances of gun trust later on, but with current events being as they are, and 100 marches nationwide yesterday over the Florida versus Zimmerman case involving Trayvon Martin's death, and the hubbub all across the media, all in the Sunday morning talk shows about stand your ground, I thought it behooved us to do a little bit of discussion on Georgia's version of the stand your ground law this week. Georgia's version is found at OCGA 16-3-23.1 and essentially says that there's no duty to retreat when protecting one's self, another person, or one's home, one's habitation, or property extending from habitation, like a motor vehicle, presumably an RV, presumably some sort of a boat that would constitute something akin to a habitation where it's an enclosure and one's in. So this law was passed in Georgia in 2006. There's a handful of cases that flirt with the application of stand your ground in Georgia. The middle one is the most difficult fact pattern because it happened in December the 5th, 2005, just weeks before, or arguably months before, the law went into effect here in Georgia, the stand your ground law in 2006. So the opinion went up. A man was convicted in Cobb County for aggravated assault and felony manslaughter. Well, let me lay out the facts like this. A man in Cobb County was convicted for aggravated assault and felony manslaughter when a man came onto his home named Epp. McNeil was the defendant, so the case was McNeil versus State. It went up to the High Court here in Georgia, and they turned down the decision in 2008 that affirmed the Cobb County jury's conviction. McNeil was not at home. McNeil's son called him and advised him that there was a man on their property, that the son had gone out, asked him to leave, and the man refused and threatened him with a knife and almost cut him with a knife. So he called his father, McNeil. McNeil told the son to stay inside the house and that he would be there. McNeil, on the way to the house, took his firearm out, put a magazine in it, and loaded a live round in the chamber. When he got to the house, he was on the phone with 911 and told the operator in all too familiar language that, look, you better get the cops here fast. I may get ready to go out and whip this guy's ass. So it turns out that Epp was a contractor that McNeil had hired to do some work on McNeil's roughly $450,000 to $500,000 house. Now, Epp had a reputation in the community with other people that had hired him as being sort of perhaps not altogether tightly wrapped. Anyway, there was a lot of testimony and a lot of evidence that Epp had problems with a lot of different people with whom he did business, radical type behavior, irrational type behavior, perhaps hinging towards the violence at some points, or other people were voiced. The evidence showed that they were afraid of him as well. Okay, so as the police are on their way, McNeil then goes out and confronts Epp, who then starts coming at McNeil. But evidence was that Epp his hands never left his side. Yet McNeil and Epp started raising their voices. McNeil started backing away. So here you've got a retreat. So pre-stand your ground said you needed to retreat before you could justify using deadly force. McNeil is retreating, and Epp continues to pursue him. But remember, Epp's hands never leave his side. But McNeil's knowledge was that Epp had previously tried to use a knife on McNeil's son. At one point, McNeil discharged the weapon, fired a round as a warning round, And yet this did not deter Epp, who kept on coming after McNeil, who the evidence showed allowed Epp to come within 3 feet of him before raising the pistol and firing a fatal shot to Epp's head, who then died of a gunshot wound to the head. Now, when the investigators arrived at the scene and found Epp's body, they did search him, and sure enough, there was a knife in Epp's front pocket, but it was folded. So, the issue becomes whether McNeil's testified, apprehension of Epp using his bare hands as a deadly weapon was justified McNeil in defending his son, himself, his habitation, using deadly force. The case turned out McNeil, the Cobb County jury said no. The court convicted him, as I said before, and the conviction was upheld on appeal. And the case again, McNeil versus State, a 2008 decision here in Georgia. So look forward to some lively discussion from you guys. We'll dig into the dissent's opinion, who felt, next time we discuss the case, but the dissent was a very strong dissent, said that they felt that that justice felt that McNeil was justified and did not have to await being pummeled by Epp or whatever, possibly being disarmed and being shot with his own gun by an irrational Epp. So anyway, great discussion and a nice kickoff to the blog here. We'll do a lot of video blogs, and we'll follow up with some written material as well. Again, I'm Wally. Glad to have you aboard here at GwinnettGunTrust.com. Like us on Facebook, Georgia Gun Trust. And as always, see us at WRNicholsLaw.com, where we're protecting your rights and maintaining your trust.